Mr. Haeri practices public and international law and international arbitration.
Thank you. I'd firstly like to thank the Institute for Cultural Diplomacy for inviting me to speak here. I'd also like to say that it's a great honor to speak after Professor Alvarez's tour de force of the soft power of the United Nations. He has written with great insight on a number of the issues that I am going to address today. So considering the title of my talk, The Future of the UN, reminds me of Yogi Berra's comment, slightly paraphrased, that one can predict anything except the future. So with that in mind, I'll make two qualifications. The first is that I don't intend to be comprehensive in any way. Rather, given the time constraints, I will focus on four relatively high-level predictions for the future of the UN. The second qualification is that my time horizon is 20 years. Now, that time period was proposed by the conference organizers, and it's fine for me, because no one is likely to remember my talk in 20 years when my predictions turn out to be incorrect. Since I practice public international law in a law firm, I should note that my comments are made in a personal capacity. So my predictions relate to two phenomena that I believe the world is experiencing and which I expect to continue in the next 2 decades. The first is the diffusion of power between states and the reconfiguration of a more multipolar world than existed at the end of the Cold War. And the second is changing notions of security, from the concept of state security towards the notion of human security. And this recognizes individuals as the ultimate beneficiaries of security. Now I'll briefly mention my four predictions before addressing each of them in turn in more detail. The first of them relates to human rights and absolute notions of state sovereignty. And there is, as Professor Alvarez noted, something of a tension within the UN framework between the respective norms of human rights and state sovereignty. In the next 20 years, I think that balance will tilt somewhat away from absolute notions of state sovereignty, at least for mass atrocity crimes, such as war crimes, genocide, and crimes against humanity. My second prediction is that regional organizations will play an increasingly important role as regards international peace and security. To that end, we can expect to see varied types of collaboration between the UN and regional organizations. The third prediction is that the UN Security Council will likely be reformed in the next 20 years. The new configuration of the Security Council will be more representative of a world that is very different from 1945, when the UN Charter entered into force. And the fourth prediction is that despite the permanent existence of the International Criminal Court, I think we can expect to see more ad hoc tribunals in the area of international criminal justice that blend international and domestic laws, staff, and considerations in various ways. Now, what these four predictions have in common is that each goes, in a different way, to the legitimacy of the UN. The key currency of the UN is its authority, and that is intimately linked with its legitimacy. To maintain that legitimacy in an evolving world, the UN will have to change. So I'd like to turn first now to the issue of human rights and state sovereignty. Now, the UN Charter reflects both of these norms. As regards human rights, the preamble to the UN Charter starts with the words, "We, the peoples." It reaffirms faith in fundamental human rights. In Article 1, it includes as a purpose of the UN encouraging respect for human rights. Yet, state sovereignty is also very clearly reflected there. Consider, for example, Article 2.7 of the UN Charter, without prejudice to enforcement measures, which limits UN intervention in matters which are essentially within the domestic jurisdiction of any state. So there's an unresolved tension here between human rights and state sovereignty. States may, and sometimes do, argue that the UN should not intervene regarding their human rights violations, as doing so would violate their sovereignty. So, why do I think that the balance will tilt away from absolute notions of state sovereignty, at least for mass atrocity crimes? I'll give you 3 reasons for that anticipated tilt. The first is the changing nature of conflicts in the world, with more intrastate conflicts and the increased propensity of those conflicts to affect international peace and security. That means the UN will increasingly look at what is happening within states as well as between them. Now you can see that reflected in this chart here. Not very clearly at the bottom, but one of the lines at the bottom relates to interstate conflict, which is one of the dark lines. And the line at the top, which is the biggest part of the graph, if you like, is intrastate conflicts, which is conflicts within states. And you can see how many more states there are, how many more conflicts there are within states than between states. Now that means that the UN is increasingly going to look at what is happening within states as well as between them. Following the end of the Second World War, the UN Charter was largely designed to address the issue of states waging war on other states. Thus, at the heart of the UN Charter is Article 2.4, which obliges member states to refrain from the threat or the use of force against the territorial integrity or political independence of any state. However, the changing world context has meant that internal conflicts, which have long been more numerous than state-to-state conflicts, are now far more numerous. And such intrastate conflicts can have serious ramifications for international peace and security, including through issues such as refugee flows across borders and terrorism, to name but two examples. So to ensure international peace and security, intrastate conflict is of concern to the UN and the international community. Therefore, as the UN adapts to address intrastate conflict, it will become increasingly difficult for states to cite sovereignty as a carte blanche for mass atrocity crimes. Now, the second reason is the emergence of individuals as participants in international law and the emerging notion of human security. Now, at the time that the UN Charter entered into force in 1945, there was a neat dichotomy in public international law between subjects and objects. States were subjects of international law with rights and obligations, and individuals were mere objects. They didn't have rights, nor were they generally subject to obligations in international law, with the notable exception of piracy. Now that paradigm looks increasingly dated. And as the New Haven School has shown, it may now be more helpful to consider individuals as participants in international law. Individual rights and the ability to vindicate those rights directly are reflected in instruments such as the European Convention on Human Rights and fora such as the European Court of Human Rights. In the investment context, we see individuals and companies commencing international arbitrations directly against states under bilateral and multilateral investment treaties. On the side of individual responsibilities, we see remarkable developments in international criminal justice, such as the establishment of the Permanent International Criminal Court with jurisdiction over certain crimes. The development of individuals as participants in international law parallels the idea that human security, rather than simply notions of state security, should be an objective of the UN. That, in turn, points towards some restrictions on absolute notions of state sovereignty. To be clear, I am not in any way predicting the demise of the state or the important notion of state sovereignty. Such arguments remind me of Mark Twain's comment that the reports of my death are greatly exaggerated. But I think that the currency of absolute notions of state sovereignty will continue to depreciate in the face of mass atrocity crimes. Now, the third reason is the norm of responsibility to protect, or R2P, and this is a way of reconceptualizing sovereignty as responsibility. Since the term responsibility to protect was first coined by the International Commission on Intervention and State Sovereignty in 2001, it has been endorsed at the UN World Summit Report in 2005, by the UN Security Council, by the UN General Assembly, and on at least two occasions by the UN Secretary General. And significantly, it was invoked by the Security Council in Resolution 1973, imposing a no-fly zone over Libya. So what are the parameters of R2P? Well, they are firstly that each individual state has the responsibility to protect its populations from genocide, war crimes, ethnic cleansing, and crimes against humanity. Secondly, the international community should assist states in exercising that responsibility and in building their protection capacities. And thirdly, when a state is manifestly failing to protect its population from those four specified violations, then the international community should take action in a timely and decisive manner through the UN Security Council and in accordance with the UN Charter. Such action may be coercive, but military intervention is only a last resort. To its supporters, R2P changes the parameters of the debate away from a false choice of human rights versus sovereignty, towards a notion of states' responsibilities for upholding human rights. To its detractors, it's imprecise, being either all things to all people or nothing to anyone. Now, the precise parameters of R2P are contested, and I'm not sanguine about it realizing the aspiration of never again regarding genocide, still less other mass atrocity crimes. Clearly, R2P has been applied selectively, and Darfur has arguably shown its limits. However, it does challenge absolute notions of state sovereignty, and it seems to have maintained a purchase in the last decade that may endure. So my second prediction, which is the increasing importance of regional organizations as regards the maintenance of international peace and security. Now, there's certainly nothing new about regional organizations within the framework of the UN Charter. In fact, Chapter 8 of the UN Charter expressly provides for regional arrangements, and we can see a reference, for example, in Article 52.1 of the UN Charter, which I won't go through, but you can see there. So why do I think there will be increasing collaboration between the UN and regional organizations on peace and security? I'll give three reasons. The first is capacity constraints at the United Nations. Now, if we see that table, you see the number of peacekeeping missions in which the UN is engaged dramatically increasing since the UN Charter of 1945. Now, given that tremendous growth in peacekeeping, that has put a considerable strain on UN capacity and budgets. And partly as a result of that, the UN will increasingly look to regional organizations to carry out roles that it might otherwise have performed. The second reason is legitimacy. As organizations like the African Union and the Arab League develop collective responses to problems in their regions, the UN is likely to take note. Informed as those organizations are by the regional context and local knowledge, regional responses can have legitimacy, both locally and on the global stage. Consider, for example, the comments of China's ambassador to the UN regarding UN Security Council Resolution 1973 imposing a no-fly zone on Libya. He said that China had not blocked the passage of the resolution, quote, because it attached great importance to the requests of the Arab League and the African Union, end quote, in that regard. Consider also the Arab League's recent role in requesting a Security Council resolution on Syria. Although that draft resolution was blocked by vetoes from Russia and China, the Arab League's central role in this unfolding issue is undeniable. The third reason is the effectiveness of regional organizations. Regional organizations' proximity to peace and security issues in their regions and a deeper understanding of their context can add particular value to the effectiveness of an international response. Coordination between the UN and regional organizations can also take many forms, which facilitates flexibility. Consider some examples. In Haiti, the Organization of American States provided support within the context of a UN-led mission. With a different order, in Liberia, ECOWAS established a military observer group called ECOMOG in 1990. After brokering the peace agreement in Cotonou in 1993, it was the UN Security Council which subsequently established UNAMIL to support ECOMOG in implementing that peace agreement. Another example is UNAMID, which is the joint African Union and UN force in Darfur. There are many other examples that one could give. Now, there clearly will be issues for primacy with regard to the relationship between regional organizations and the UN. I don't expect that the arrangements will necessarily be very tidy, nor sequential in any particular order. But in responding to a messy world, I think that regional organizations will play an increasingly important role collaborating with the UN regarding international peace and security. Now that leads on to my third prediction, which is reform of the UN Security Council. In 1965, the number of members of the UN Security Council was increased from 11 to 15. The question of Security Council reform was raised again in 1979 in the UN General Assembly. And in the last 3 decades since then, there have been no further changes. So, predicting Security Council reform in the next 2 decades might be rather like predicting Godot's actual arrival. Nevertheless, I think the reform of some kind probably will happen in the next 20 years. Precisely how might require prophecy, not prediction, so I will try not to stray too far into guess territory. However, let me say what I don't think will happen. First, I don't think that the veto-wielding permanent members of the Security Council will give up their veto. I don't even think they will agree to the veto being curtailed, for example, by removing it for certain issues. And given Article 108 of the UN Charter, which you can see on the slide there, and which relates to amendments to the Charter, the permanent members can block such a change to the Charter. Second, I think it's unlikely that any new members of the Security Council will be given a veto power, even if they are to be permanent members. Germany, Japan, India, and Brazil, 4 candidates for permanent seats on the Security Council known collectively as the G4, appear to have recognized as much. Article 23 of the UN Charter perhaps gives us some terms of reference for the composition of a revised Security Council. And you can see there it refers to non-permanent members being elected to the Security Council on the basis of their contributions to the UN and to equitable geographical distribution. So if the Security Council was to be reformed by the addition of more permanent members, and that is a big if, contributions to the UN would likely mean that Japan and Germany would become permanent members. They are the second and third biggest contributors to the UN budget. The saying of no taxation without representation would presumably be their refrain. In terms of geographical distribution, 2 African states would be likely to become permanent members, most likely South Africa and Nigeria or Egypt. India, projected to be the most populous country in the world within the next 20 years, would likely get a seat, as would Brazil, the most populous and economically powerful state in South America. Now, such a configuration is by no means inevitable, and it faltered at the World Summit in 2005, despite considerable encouragement by then Secretary General Kofi Annan for reform. He said in 2003, and his words are on the slide, "If you want the Council's decisions to command greater respect, particularly in the developing world, you need to address the issue of its composition with greater urgency." Those words were not heeded then, but maybe at some point in the next 2 decades. Leading on to my 4th prediction in the area of international criminal justice. Alongside the idea that state sovereignty is not absolute in the face of mass atrocity crimes is the idea that there should not be impunity for individuals responsible for such crimes. As the Nuremberg Tribunal held in 1947, crimes against international law are committed by men, not by abstract entities, and only by punishing individuals who commit such crimes can the provisions of international law be enforced. And we see here a timeline of the development of international criminal justice, if you like, and after the Nuremberg and Tokyo tribunals at the end of the Second World War, there was something a lull of international criminal justice developments until 1993. And in the mid-90s, we then have the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, established by the UN Security Council. With the creation of a permanent court, the International Criminal Court, in 2002, to try the most serious crimes of concern to the international community, we have an undeniable watershed in international criminal justice. But is that the end of the story? I would suggest not. Rather, I think that ad hoc tribunals that combine international and domestic laws, staff, and considerations in various ways will increasingly be set up in the next 2 decades to address particular situations. Why? Well, first, despite its many advantages, the ICC does have some limitations, which have already been discussed today. These include, for example, that the United States is not a party to the Rome Statute, despite having signed it, which obviously established the International Criminal Court. The ICC has also come under considerable criticism for the fact that 7 situations it is currently investigating are all in Africa. In addition, purely international criminal tribunals have been criticized for being too costly, insufficiently responsive to victims and local considerations, and for failing to enhance capacity building at the local level where it is needed. On the other hand, while domestic tribunals may be more reflective of local considerations in criminal justice, local political pressures and a lack of international involvement can raise concerns about victors' justice. To put it simply, the argument in favor of ad hoc tribunals, such as the Special Court for Sierra Leone, is that they can take the best of the international and domestic in a hybrid tribunal. For example, an ad hoc tribunal can apply both international law and domestic law, as the Special Court for Sierra Leone does. Such tribunals can help with capacity building and development of the rule of law at the local level where it is most needed. They can benefit from local knowledge and contextual understanding, and they can be far more cost-effective than international tribunals. Now, I'm conscious that hybrid tribunals covers a wide array of different sorts of tribunals. The legal bases, the locations, applicable laws, and staffing, to mention some issues, can differ considerably across such tribunals. But that's one of the strengths of hybrid tribunals, their flexibility. As Professor Casses has argued, international criminal law deals with the darkest side of humanity. The magnitude of this task is such that there is no single response to the multifarious aspects of international criminality. For a messy world that requires flexible responses, I expect that hybrid tribunals will be a part of the future of international criminal justice. That takes me on to my final observations. And as I noted at the outset, there are two major developments, as I see them, that may provide a tailwind to my predictions. The first is a diffusion of power between states and the emergence of a more multipolar world. This development may facilitate UN regional organization collaboration and increase the likelihood of UN Security Council reform. The second is the ongoing evolution in the concept of security from state security to human security. And alongside this is the evolving view of individuals as participants in international law, with both rights and responsibilities. These factors may call into question absolute notions of state sovereignty and encourage measures to end individual impunity for mass atrocity crimes. To conclude, we live in a very different world to that in 1945 when the UN Charter came into force, with different problems. These threats include considerable intrastate conflict, the problem of failed states, nuclear threats, and terrorism, to name but a few issues. In 20 years' time, more differences will emerge compared with the world in 1945. They will be amplified by the shift of power towards a more multipolar world. Many in the world will welcome that, but it will make diplomacy both more important and more difficult to exercise. To maintain legitimacy and hence authority in that changing world, not only is the UN likely to change, but it must change. The UN will have to continue to evolve and adapt to meet the needs of our changing, dynamic, and increasingly messy world. I look forward to the discussion of how things have unfolded in 20 years' time, even if these predictions make me look foolish along the way. Thank you.
Thank you very much, Mr. Haeri.